There's a lot of misinformation about Amber Heard appealing after losing her case to Johnny Depp. In this video, we'll take a look at what's involved in making an appeal from Amber's perspective, not from Johnny Depp's perspective. We'll also discuss what is actually reviewed on appeal. And at the end of this video, I'm going to give you some insight into what I expect the decision to be if Amber files an appeal. But first, let me say this. Let me issue a disclaimer. Nothing in this video should be considered legal advice. If you're dealing with an appeal, talk to an attorney and don't rely on the information I'm about to give you for your appeal. Every appeal is different. Every appeal has different facts and circumstances. Second, I'm an attorney licensed to practice law in the Commonwealth of Massachusetts, the Federal District Court of Massachusetts, and the military courts of the United States. Although, like any other attorney, I can practice in other states with the permission of the court in that state. Also, the Amber Heard and Johnny Depp trial was heard in Virginia. And again, I'm a Massachusetts attorney. So I'm going to give you my take on the case from the perspective of a Massachusetts appellate attorney. And I'm going to be giving you a lot of value in this video. So stick around to the end where I'll give you the odds of Amber winning on appeal. Also, while you're at it, please subscribe to my channel while it's still fresh in your mind. I'd really appreciate if you took the time to do that right now. With that out of the way, I'd also like to express that a skilled attorney with a lot of preparation and resources can make, well, a sow look like an angel and vice versa. It's almost always true that nobody is ever as good or as bad as they seem, and Amber Heard was made to look pretty bad. That doesn't necessarily mean that she is bad. That just might mean that her attorneys did less than an average job preparing Amber for the witness stand. That's something to think about when considering what has to happen for Amber to prevail in her appeal. First, Amber has to pay a filing fee and post an appellate bond. In Massachusetts, someone appealing a decision doesn't have to post a bond. In Virginia, a bond seems to be required. The judgment against Amber Heard totaled $10,350,000. How can Amber appeal if she doesn't have that kind of money? Amber's trial counsel, Elaine, went on TV saying Amber doesn't have money. It looks to me that in Virginia, a bond must be posted to cover the cost of judgment. There goes my Massachusetts accent. But are there ways around this requirement? There might be. In my experience, if you think creatively and outside the box, there's most times an alternative. For instance, maybe Amber could petition the circuit court in Virginia for a waiver of the bond. If that's denied, she could appeal the decision to the appeals court. The argument being that courts are designed to let the public pursue justice. If Amber believes that she suffered an injustice, then the argument would go, money shouldn't necessarily get in the way of justice being served. Denying her the ability to appeal would be an injustice. So you get the idea. A creative attorney should be able to figure out a way around that bond issue. Presenting this issue as a black and white issue, in my opinion, it's not. In Massachusetts, the mechanics of an appeal are pretty simple. If a person wants to appeal, they file a document in the court they lost in, usually within 30 days from the judgment. And that starts the appellate process. In my experience as a Massachusetts appellate attorney, an appeal can run from anywhere between 1 and 2 years. So it's a lengthy and difficult process, and it's a complicated process, and it shouldn't be taken on lightly. Once a case is actually filed in the appeals court, each side drafts what's called an appellate brief to present to the court. Amber would be the first to file her brief. Then Johnny would have a chance to file his own brief responding to Amber's. In Massachusetts, a brief cannot exceed 50 pages. That seems pretty long, but every fact in the brief must be supported by the record, and legal arguments must be supported by case law and statute. So what can be argued on appeal? Again, I like to be creative. I hear a lot of talk that Amber can't re-argue the facts on appeal, and that's generally true. But again, she should be allowed to present the facts to the appellate court in a light that she interprets them. In other words, a good attorney is going to frame the facts of the case in a light that reflects well on Amber. Generally on appeal, only legal issues are reviewed by the appellate courts. Sometimes facts can be an issue on appeal. For instance, let me give you an example. Let's say that Amber's legal team wanted to present some evidence at trial about domestic abuse, and Johnny's legal team successfully petitioned the court in a pretrial motion to keep that evidence out. If Amber objected to that ruling, that could be an issue on appeal. If overturned, the facts from that motion might cause the case to be reversed or retried. I've heard people talking about preserving the issue for appeal. That means that if a party felt that a judge made an incorrect legal decision during the trial, that party that felt the decision was bad needs to object. This could be, for instance, that a witness's testimony during trial was hearsay. That party would need to object to that hearsay in order to preserve the issue for appeal. When I represent someone on appeal and an issue is not preserved for appeal, I'll ask the appellate court to throw that issue right out. But again, creative attorneys usually find a way around the general rule. There's a way to get around unpreserved issues. Let's say, for instance, that Amber argues on appeal that social media unduly influenced the decision of the trial court. And let's say also that Amber's legal team failed to raise the issue with the circuit court. Can that issue be raised on appeal? My opinion is yes, it can. And it can under what we call in Massachusetts, and what I've seen in other jurisdictions, the substantial risk of miscarriage of justice standard. That's a mouthful, huh? So Amber could argue, yes, I didn't preserve the issue for appeal, but the issue is so important that if it isn't reviewed by the appellate court, the result would be a substantial risk of miscarriage of justice. Again, a mouthful. This standard is harder to prevail upon, but it would still give Amber a way to be creative and think outside the box on appeal. And in law, I think that's the name of the game. There also may be another way to get the appeals court to review the evidence, as if they were rehearing the case. In Massachusetts, we sometimes will ask the appeals court to review an issue, what's called de novo. De novo is a Latin word that basically means that the appellate court is reviewing the evidence in effect for the first time on appeal. This would generally only happen when the documentary evidence is at issue and the appellate court would be in the same position as the trial court in interpreting the evidence. This type of review, well, it rarely happens. But again, if we're thinking outside the box and with some creativity, the strategy could be used by Amber's appellate team. So the third and the last point is that it's difficult to get a judgment reversed on appeal. I've successfully done it. Usually, though, the person appealing they lose. And the person defending the decision of the trial court wins. That being said, if Amber can overcome the issue with posting the bond, she'll probably appeal. Any attorney with good experience in appeals who thinks creatively and outside the box and has enough resources will be able to come up with a whole host of issues that can be presented to the appeals court. I'm confident of that. It's impossible to go through a 10-day trial without some legal mistake being made. Whether that issue will prevail on appeal is a different story, but it still gives Amber a chance. To recap, although Amber faces some challenges, there's almost always a way to overcome those challenges. A bright, creative attorney should have no problem making a good case for Amber Heard on appeal. One last point is that after the parties file their appellate briefs and have presented their argument to the panel of appellate justices, the case is not decided instantly. It could take months to make an issue, to issue a decision on appeal. During this time, the case will have faded from the public memory, and the justices won't be as pressured to make a decision. This could play well in Amber's favor. Will Amber win on appeal? My opinion is that Amber, along with anyone else asking for a review of an unfavorable decision, generally will not prevail. I hope this video has been helpful. My name is Rob, and if you haven't done so already, please subscribe to my channel.